Anyone have any questions? Any questions so far? Or so far so good? You don't have questions? Okay, if you do not have questions, we will move on to look at special negligence doctrines, or in other ways, we will look at special types of negligence, okay? And they are professional malpractice, negligence inflictions of emotional distress, negligence per se, res ipsa loquita. Res ipsa loquita, that is the Latin term, okay? And Good Samaritan law and vicarious liabilities, okay? So first of all, we will look at professional malpractice. What professional malpractice mean? Professional malpractice means the liabilities of a professional who breaches his or her duty of ordinary care. Ordinary care of the professional will mean the ordinary professional, okay, level, okay? And the reasonable professional standards are used to determine whether there is a commissions of professional malpractice actually applied in medical malpractice, legal malpractice, and accounting malpractice. Okay, they are the most popular one. Okay. All right. So I give you an example and asking you whether a defendant or a plaintiff can successfully sue against the defendant under professional malpractice. A is a lawyer. Okay, A is lawyer. B know that A is a lawyer. Okay, and B approach A to ask for a legal advice. Okay, without payment of fee, without payment of legal fee. Okay, B approach A, and B know that A is professional lawyer, and B asks for advice. Okay, and A give an advice without reasonable care, without checking carefully, and the advice turned out to be untrue. B relies on the advice in order to conduct a transaction, and B suffer some damage, some loss. B take legal actions against A under professional malpractice, can be succeed. Not the first case. The second case that A did not know that B did not know that A is a lawyer. We didn't know. We just asked for advice. Okay? And A is also given advice without reasonable care, without checking carefully. And it turned out that the advice is untrue, the advice is wrong. And then B suffers some loss. And B is also take legal actions against A under professional malpractice. The question is, can B succeed in both cases? The differences between the two cases is that The first case, B know that A is a lawyer. The second case that B doesn't know that A is a lawyer. Anyone have any idea? Hello, hello everyone. Have you back? Hello, everyone in the class? Okay, okay. Anyone have the answer to the two cases that I have just read?
Miss, I have a question.
Yep.
So, as to professional malpractice, does a professional uh, have to provide a kind of services to other people to create um, like a condition for professional malpractice?
Um, you mean that they need to, sorry, what do you mean? They need to have a contract or what?
Yes, a kind of contract.
Oh, okay, contract. Yeah, that could be a type of contract, but that will govern by contract law. In this case, there is no contract because there is no consideration. Okay, the advice is given for free.
Yeah, I understand the example. However, I'm just asking about professional malpractice. Does a
Mm.
contract or transaction between a professional and other people compulsory to constitute professional malpractice?
No.
No.
Because
Okay.
this is a tort. You remember the differences between contract law and tort is that under tort law, you can claim damages even though there is no contractual relationship. If there is a contractual relationship, and then you can take legal actions under contract law.
I understand.
Yeah.
Then, as to the example, the two cases, whether B knows A is a lawyer or not, in my opinion, B still can claim for damages because um, I think that professional malpractice is not subject to whether uh, the plaintiff is aware of defendant professional or not.
Mm. Okay. All right. Okay. Good. Anyone else have different idea? Anyone have different idea? Right. Okay. So you mean that because B didn't know A is a professional, so A will not be liable? That's what you mean, or what? Hmm. Yeah. Yeah. Understand what you mean. Continue. Yeah. Mm. Yes. Yeah. Correct. Okay. Understand, everyone? So if for professional malpractice, it is requirements that the defendant, the plaintiff need to know that the defendant is a professional in order to claim. Okay. All right. Then, okay. So that is about the requirement for professional malpractice. And remember that for common law countries, in fact, common law countries, the reliant elements is very important. Okay. Right. So the next thing is that defense. One defense available to professional malpractice is appropriate disclaimer. Okay. So what is an appropriate disclaimer mean? It means that if you already, the professional already make exclusion clause or a disclaimer that, okay, my advice is just for general things, okay, I did not look at the materials, so therefore I will not be responsible for the negligence, for anything happen with the liabilities that could result. So in that situation, you make an appropriate disclaimer, and because you already make an appropriate disclaimer, you could not be liable. Okay, so if you make an appropriate disclaimer and you could not be liable. Okay, the reasons is that because this is actually negligence, okay, and you will not charge for it. If you charge for it, it means that you enter into a contract, you have a contractual relationship with a person, the plaintiffs, and in that situation, you could be liable under contract, okay? But if you have no contract at all, and then in that situation, you could only be liable if you are repaired for the liabilities. But if you are not repaired for the liability, you can make an appropriate disclaimer. And then after you already make an appropriate disclaimer, you could not be liable. Okay? Understand? Yeah, okay. All right. So the next types of special negligence doctrines in negligence inflictions of emotional distress. So when we look at this type of tort, do you remember the other very similar name in intentional tort? very much similar name. Do you remember what are the types of intentional tort would be very much similar to this type of tort? Anyone remember? Do you remember the tort is called intentional inflictions of emotional distress? Intentional torts, intentional inflictions of emotional distress. And do you remember what does the tort about?
Excuse me, Miss, could I answer your question?
Yes, sure. Yep.
Yeah, as I remember that the negligent infliction or emotional distress, that means the defendant intentionally or or unintentionally conduct some have sorry the defendant intentionally or unintentionally have some extreme or outrageous conduct that affect to the emotion to another person.
Right. Good. Your name is
My name is Thảo.
Thảo. Okay.
Yeah.
Thank you, Thảo. All right. Yes, correct. So here we look at negligence inflictions of emotional distress, and it seemed to be totally different. Okay. From intentional inflictions of emotional distress. Okay. All right. So for negligence inflictions of emotional distress, the requirements is when a person witness another, when a person witness an accident happen to that person family members. Okay. Family members. Okay. And the plaintiffs witnessed that accident, and because of the witnesses of that accident, the plaintiff suffer mental problems, mental disorder, emotional distress, but some states requires evidence given by medical clinic doctors. Okay? Understand? Understand? Anyone have any questions? Understand? No questions? Right? Okay, if you have no questions, we then look at the next types of special negligence doctrines, which is negligence per se. So what does it mean? This means that when a person commit a breach or violate a statute, you remember a statute? What statute mean? What statute mean? Remember?
Statute is statutory law or written law or legislation.
Yeah, correct. Yes. Right. So if there is a provisions of law, whether it is statutory law or it is a regulation, okay, regulations means sub law, okay. And if there is clear provisions of law that saying that you could be liable to pay damages to someone if you commit this behavior or conduct, okay. And then in that case, you don't need to apply the test, the normal test of negligence. Okay. All right. So if there is specific provisions of law, either in the law documents or regulation. Okay. Understand? Any questions? I will explain to you a bit about the second requirements that the plaintiff must be within the class intended to be protected, which means that if the statute, the rules that cover that kinds of plaintiffs, okay, the plaintiff can only take legal actions when the statute actually cover that situation, okay? All right. And the purpose of that statutory law is to prevent the types of injury suffered. Okay. All right. All right. Any questions? For example, I give you an example. If there in the traffic law, there provision saying that a person who causes injury to someone, if a person passing a red light cause injury to someone, have to be responsible to pay damages for that person, right? So if there is provisions of law saying so, and then if you do so, okay, you will be subject to liabilities, would mean that you have to pay the damages to that person regardless, and there is no need for the plaintiff, the one who have suffered injury because of your behavior, to prove the general test of negligence. Okay, the 4 questions that we discussed earlier today. Okay, so that's called negligence per se. Okay, understand? Any questions? No questions or yes? Okay, I assume that no questions if you keep silent. Okay, everyone?
No question, yes.
Okay. All right. The next one is res ipsa loquitur. Okay. That is the Latin terms. Okay. In English, it means the thing speak for itself, which means that it's very much obvious. Okay. So the defendant had exclusive control of situation that caused the plaintiff injury. If the plaintiff can prove that the defendant had exclusive control, which means that the plaintiff have nothing to do in the situation. Okay, the plaintiff is absolutely controlled by the defendant. And second, the injuries could not have ordinarily occurred but for someone negligence. Okay, you remember the but for test? Remember about but for test?
Yes, I remember the but for test.
What means? What
That
is
is the test used in the test of negligence.
But can you explain a little bit more about the meaning of the second sentence on the screen, on the screens?
So as I understand that this could that this sentence means that the injury would not the injury would be also occur without the action or omission of the defendant.
Mm,
That means that it doesn't have the causal link.
mm, mm. Okay. Okay. All right. Which means that there be a cultural link, right? There could be a cultural link between the course of action, okay, and the damage result. Okay, so the example given here is very obvious. You can think that surgical instrument left inside patient after surgery. Okay, surgeries. Okay, so if the doctor left something inside of the body of the patient after the surgeries, and it could come to the conclusions immediately that the doctors were negligent. Clear? The plaintiff in that situation doesn't have to prove all of the 4 elements that we discussed earlier today. Okay. Or crossing elevators. So when you step on the elevators or the lift, you are in absolutely control of the equipment. You can't do anything. If anything wrong happens with the lift that you are inside or with the elevators, and you can't do anything. So therefore, if something wrong happens, the owner, the operators of that lift or elevators have to be responsible. Understand? Okay.
Okay, Miss.
Okay. So we move on to look at the next types of special negligence doctrines, which is Good Samaritan law. Okay. So what Samaritan's law mean? You know that usually if you see other person involved in the accident or injured in the accident, the law doesn't require you to have that person directly. The traffic law of many states in the United States requires that when you see an accident happen, okay, the victims, okay, but you are not required to have that person, especially for medical aid immediately. What it requires by law is that you stop and then you call the police, you call a responsible person, okay? The law doesn't require you to help directly with the victims. But if you try to help them, okay, and then if you make the situation even worse, and you could be liable under the tort of negligence. Okay, so that's what the law generally provides. Okay, you are not required to help someone directly when that person involved in the accident if you have no experience or knowledge of how to do that. The law only requires you to stop when you see the accident and you call the police or you call person who have a knowledge to help. And if you try to help, and you make the situation even worse because you have no knowledge, you have no experience, you don't know how to do it properly, okay, appropriately. You just do it because you want to help people, and you make the situation even worse. And in that situation, you could be liable. Okay, so if because the general law requires so therefore it's like people afraid of helping the other people. When they see accident, they are faced that if they have that person, and then they make the situation worse, and then they will be responsible. So that's why the law develops a doctrine what we call Good Samaritan law. And Good Samaritan law protect medical professionals who stop and render emergency first aid to anyone in the emergency situation, and it helps to relieve them from liability for ordinary negligence. But it requires that must be medical professional, because medical professionals have a knowledge, have experience of how to help people. So if there is negligence, is actually only a negligence. Okay. Okay. No relief for gross negligence or intentional or reckless conduct. So now I just want to ask for you to classify or to explain more about the differences among the three terms: gross negligence, intentional conduct, or reckless conduct. Okay. Anyone?
Yes, I would like to tell the difference between those terms.
Yeah, sure. Thank you. Yep.
The first one is gross negligence. Gross negligence is a failure of a person by act or omission to exercise reasonable care and skill in performing or failing to perform an obligation.
Mm.
And we talk about intentional tort is where a person do something in purpose, foresee the consequence and want the consequence to occur. And we have reckless conduct is when a person know that his or her behavior could cause injury to someone and believe that he or she can control the result or the result would not occur. So those are the difference between gross negligence, intentional, and reckless conduct.
I'm sorry that I missed your points on the gross negligence. Can you repeat about the gross negligence, please? Thank you.
Yes, gross negligence is a failure of a person by act or omission to exercise reasonable care and skill in performing or failing to perform an obligation.
Well, so how could gross negligence differ from negligence generally?
I need to do a research on that again.
Okay, so you are correct when you explain about the differences between intentional tort and reckless conduct. In fact, the gross negligence and reckless conduct is very much similar to each other. Okay, all right. So gross negligence and reckless conduct is very much similar, which means that you didn't intend, but you do something because you believe that the result could not happen, or you can control the result, you can control the consequences. Okay. But in fact, you cannot do that. Okay, very good. Thank you, Nga. All right. So a good Samaritan law, you understand that already, right? But it's applied only to a medical professional or a person who have been trained in first aid. Okay. If you have been trained in first aid, and you will be protected by this defense. Okay. So now we look at vicarious liabilities at a lot of types of special negligence doctrine that we have discussed today. The vicarious liabilities mean a legal doctrine that assign liabilities for an injury to a person who did not cause injuries, but who have a particular legal relationship to the person who did act negligently. So in other words, it means the situations in which it means the liabilities under negligence shifted from one person to the other person because of their relationship. Okay. Which means that the situations in which liabilities of one person is shifted to the other person. Okay, but between the two persons, there is a relationship. Okay, there is a relationship. Whether that is the relationship between parent and child, employer and employee, or the owner of the vehicle and the driver. Okay, so it means that in the situations when a child commit a wrong, but in that situations, the parent could be liable, okay? Or when the employees when they actually cause damage to the customer properties or cause injuries to a customer physical health, for example, and in that situation, if he does so in the course of his employment, and the employer could be firstly liable for the conduct of the employee toward the customer, okay? Or when the driver causes an accident to someone, and in that situation, usually the owner of the car could be responsible first to the victims. Of course, after that, the driver may be responsible towards the owner of the car, but that is governed by the relationships among themselves, between themselves. Okay, for the victims, the owner of the car could be firstly liable. Okay, understand about the vicarious liability? Okay. Clear, everyone? Understand? Any questions so far for the whole chapter about negligence? Because we will move on to look at strict liabilities in the next part. Any questions, please feel free to ask. Because we are about to finish chapter 3. Questions? No? Okay. So can we move on to the next chapter? Okay. So now we look at chapter 4, strict liability. So what are the underpinning principles of strict liabilities? And also what are the elements for strict liabilities to recognize strict liability, to prove strict liabilities. We also compare between strict liabilities and negligence. Okay, and the next part is to determine the amount of damages to be awarded and the defenses available for strict liabilities. And in the strict liabilities, we focus on product liabilities. And you will know that product liability can be either negligence or strict liability. Okay. All right. Just for a second. Okay, so now we look at them one by one, okay? So first of all, about underpinning principle. So strict liabilities mean a liability without fault. Okay, because this is a liability without fault, so it's applied only in certain cases, in a certain situation, not in every situation. Okay, so you can see here the definitions is that a participant in a cover activities will be held liable for any injuries caused by the activity, whether or not he or she were negligent. Okay, a participant in a cover activity will be held liable for any injuries caused by the activity, whether or not he or she were negligent, which means that it doesn't matter whether you was negligent or not. But if your behavior or your conduct are subject to strict liabilities, and then you could be liable regardless of whether you were negligent or not. Doesn't matter. Okay. All right. So what are the activities covered by strict liabilities? Okay. Before we move on to look at the activities that covered by strict liabilities, we look at the rationale for strict liability action. There are certain activities that can place the public at risk of injuries, even if reasonable care is taken. And for that reason, the public should have some means of compensation if such injuries occur. And it's applied to this what situation, okay, what situation that strict liabilities will apply. So before we move into details about the types of what activities covered by strict liabilities, we look at negligence and misrepresentations at a tort theories that based on fault. So if I say that negligence and misrepresentation will be proven if the defendant was at fault, am I correct? Again, I say it again. If I say that, or if I make a statement like the plaintiffs can successfully sue another person, sue the defendant under negligence or misrepresentation if the defendant was at fault. Or if I say the one of the similarities between negligence and misrepresentations is that the defendant was at fault. Am I correct and why? Anyone have an idea? Am I correct if I say that the plaintiff can only successfully sue the defendant under negligence or misrepresentations actions if it can be proven that the defendant was at fault? Anyone have an idea, please? Hello, everyone.
Can you give us a hint?
So what fault means? You
Excellent.
start from the definitions of fault. You should start from the definitions of fault.
So if someone or something is at fault, they are to blame or responsible for a particular situation that has gone wrong.
Yeah, fault mean that you doing something wrong, right? With the knowledge of the wrong, okay? Usually with the knowledge, you know that it is wrong, okay? Or you break your duty. The duty may not be a professional, may not be a lawful duties. The duty that the law requires. It can be a duty that an ordinary person, a reasonable person, and a prudent person could think that they would have that duties. For example, if you ride a motorbike on the road and you're thinking about something else, you do not focus on driving, okay? You're thinking about something else. So who can control your mind? Who can control what do you think in your mind? That equal fault. It's not necessary that it must be something that the law prohibits, not necessarily, but something that a prudent or reasonable person could do or could not do. So anyone have an idea? Anyone have an idea? So my statement, the statement that I have just said, is correct or not? I said that in order to successfully sue the defendant under negligence generalities or under misrepresentations, the plaintiffs have to prove that the defendant was at fault. Anyone have an idea? Anyone have idea, please? Anyone have an idea? What do you think? Yes or no? Whether
Yes.
I have, yeah, yes. Why? Can you explain a little bit? The answer, yes, is correct. But can you explain a bit about why, what is or what are the reasons that have you to come to that conclusion?
I have a general idea in mind, but I still cannot find a way to explain that properly.
Mm. But just say what you think in your mind. Never matter. That doesn't matter.
So, we're talking about whether negligence and misrepresentation is the person who commit negligence or misrepresentation is at fault or not. So if someone is at fault, they are blamed or are responsible for a particular situation that has gone wrong. As to negligence, they have breached a duty of care and they're responsible for their action. For misrepresentation, they mispresent the quality of a product or they choose not to review the defect of the product, then afterwards resulting to the injury or the loss of the consumer or the plaintiff. So this person also at fault, is also at fault.
Okay, yeah. So for negligence, for both negligence and misrepresentation, fault is one of the elements to be proven. For negligence, the fault is present in the second element. That is, the defendant breaks a duty of care. So when the defendant breaks a duty of care, even though he did not intend to do so, but he were at fault because he break a duty. Okay? For misrepresentation, especially for fraudulent misrepresentation and innocent misrepresentation, you can see that when a person make a fraudulent misrepresentation, they know that the presentation, the statements is untrue, but they intend to do so. That is for intentional. But for negligence misrepresentation, the person who makes such a statement have a duty of care to a person to whom the presentations is to be delivered, and he didn't check carefully. He break the duty of care as well. That is a negligence misrepresentation. So in both cases, break of duty of care means that the defendant was at fault. Is it clear, everyone? We talk about negligence generally and misrepresentation in case of negligence, okay? Because we are doing something about negligence. For intentional or fraudulent misrepresentation is probably very clear already, okay? Understand, everyone? Any other questions? If you have no questions, and we can stop here for now, please, if you have any questions,